Suing doctors is the national indoor sport. In 2019, there were 59,813 medical malpractice lawsuits filed in the United States. 1 year. Most of those lawsuits included multiple defendants, more than one doctor, including hospitals, nurse practitioners, physician assistants, dentists, veterinarians even. So if you haven't been sued, unfortunately, it's likely that you will be at some point in your career. I'm Jim Edwards. I'm a malpractice defense attorney. My offices are in Stafford, Texas. It's a suburb of Houston. What I'd like to talk about in this video is the relationship of the insurance company retained defense counsel and personal counsel if personal counsel is involved in your lawsuit. First, let's talk about them. When you get sued, you get served with papers. The plaintiff's attorney will have someone hand you lawsuit papers, and your diastolic will jump to about 300. You don't have to say anything. You don't have to sign for anything. Just kind of sigh and then immediately call your medical malpractice insurance company. But once you've been served with a lawsuit and notified your malpractice insurance company, they're going to retain a defense counsel to represent you. Now, that lawyer is almost never a direct employee of the insurance company. He or she is usually someone like me in a private law firm that gets assignments from the insurance companies. Usually that lawyer will be an experienced trial lawyer, and sometimes it'll actually be somebody who's tried a lot of cases. That's the insurance company retained counsel. And even though his or her bill is being paid by the insurance company, they're your lawyer. Their moral and legal and ethical obligation is to you first. Now, they do have an obligation to the insurance company. It's a little bit analogous to your relationship with your patient if the patient has health insurance. Yes, you report certain information to the health insurance carrier in order to get paid, but your duty is to the patient. The same with the insurance company retained lawyer. His or her duty is to you. And in fact, if there's a conflict of interest between you and your medical malpractice insurance company, then the insurance company retained lawyer is not even allowed to inform the insurance company about that. I was representing a doctor in a case once, and he told me right at the very beginning, he said, "I don't have insurance for this." And I said, "Well, the insurance company that called me up and retained me to defend you said you do." And he said, "Well, this is a procedure that was excluded from my coverage." And I said, "Well, I'm not even allowed to mention it to them." Happily, at the end of the trial, the head of claims mentioned to me, "You know, the doctor thought he didn't have coverage." And I laughed and I said, "Yes, that's exactly what he thought." He said, he'd been with us 20 years. There was no way I was going to deny him coverage. So some of the insurance companies have some pretty darn good people working for them. But the insurance company retained lawyer is going to manage the case. It's going to conduct the litigation. And in most cases, they're going to be very well qualified to represent you. Their duty is to you, as I mentioned, but they do have a duty and usually a relationship with the insurance company. We get repeat business from a lot of the insurance companies we work with, and some of those folks I've worked with for years and years. Now, the other lawyer I mentioned is personal counsel. Personal counsel is somebody that you pick. Now, the insurance company is going to pick the lawyer that they're going to retain to defend you. You can ask, and if the lawyer you're requesting is on their approved counsel list, they're likely to assign that lawyer to defend you, but they're not required to. And if you ask for somebody who is a plaintiff's lawyer or did Uncle Joe's will or something like that, they're certainly not going to have that person defend you. Now, personal counsel is somebody you pick yourself, but you pay out of your own pocket for personal counsel. Most of the time, the vast majority of cases, I don't see personal counsel involved. And the times I've been retained as personal counsel, the first thing I want to know is who is the doctor's insurance company retained lawyer. If he or she's got a good lawyer, there's no use spending money on me to help him out. In fact, I had one doctor call me one time, and I asked him who his lawyer was, and it was a good friend of mine who I respect and who I've had a lot of cases with. I said, "Doctor, there is no way I'm going to take your money when you're being represented by this man. This is the fellow I'd have defending me if I was a physician." And the doctor said, "Yeah, but I want somebody who will meet with me privately, who will work with me on my schedule to prepare me for my deposition, to prepare my testimony at trial, basically to hold my hand through the procedure." And I did some of that for him. We limited his expenses, but personal counsel is, as I say, somebody who's essentially your lawyer, not retained by the insurance company. The downside is you pay them out of your pocket. But the upside is they have absolutely no relationship with the insurance company. Now, when you're picking personal counsel, you want to find out if it's somebody that works with the insurance company that you're insured by on a regular basis. That's something you're going to want to talk to that potential personal counsel about and ask them if they can be completely independent. Because you might have a situation where you really need that personal counsel to fight for you with the insurance company. I've been retained as personal counsel when I had a doctor who desperately wanted a case settled, and the insurance company didn't want to settle it. And the doctor wanted me to serve as his advocate to get the insurance company to settle the case. I've been retained as personal counsel in situations where the doctor desperately wanted to take the case to trial, and his insurance company retained lawyer was pushing to settle the case. And as a result, the insurance company was pushing him to settle the case too. So sometimes if you need an advocate with the insurance company, that's when you would need personal counsel. And finally, of course, if either by accident or intentional you don't have medical malpractice insurance, then you're going to have to get personal counsel, because somebody's got to file the papers with the court to prevent them getting a default judgment, and somebody's going to have to defend you in the case. So I hope this helps. If it does, please return the favor and click like, follow, and subscribe, and good luck in your malpractice case.